All right, welcome to This Explainer. Today, we're diving into a genuinely fascinating 1996 case from the Constitutional Court of South Africa. We're looking at the Gauteng School Education Bill. This is really a story about an incredibly complex transition, moving from a heavily segregated past into a brand new democratic future. It's all about how the law navigates that intense friction between integrating a society and protecting cultural heritage.
So, I want you to keep this central question in the back of your mind as we go. Can a government mandate equality while still preserving cultural heritage? When a whole society commits to dismantling systemic inequality, what actually happens to groups who want to maintain their distinct historical exclusivity? It's a massive balancing act, right? And honestly, the way the South African Constitutional Court handled this provides a literal masterclass in constitutional interpretation.
Okay, here's our roadmap for breaking down this 1996 case. 1. The new Education Bill. 2. The Constitutional Battleground. 3. Shield versus Sword. 4. The Global Lens. And finally, 5. The Final Verdict. Let's get right into it. Section 1. The new Education Bill. The catalyst of the 1995 dispute.
So, picture this. It's 1995, shortly after the end of apartheid, and the Provincial Legislature introduces the Gauteng School Education Bill. The goal? Completely overhaul public schooling to align with the new democratic constitution. These new rules were designed to dismantle segregation, but man, they sparked immediate legal pushback. The bill basically banned using language testing for public school admission. It prohibited unfair discrimination based on race, culture, or religion, and it made religious classes strictly voluntary. Now, while the government saw this as absolutely essential for equal access, some minority groups looked at this and saw a direct attack on their rights. To really understand that pushback, we have to talk about Model C schools. Before the 1993 Constitution, these were semi-autonomous, highly privileged, state-aided public schools. The Afrikaans-speaking communities, who mostly controlled these schools, were terrified that this new bill would totally erase their cultural heritage and exclusivity. They felt that if you remove language testing and those state-backed religious frameworks, their unique community cohesion would just get swallowed up by enforced integration. And that fear, that's exactly what triggered this whole constitutional showdown. Which brings us to Section 2, the Constitutional Battleground, interpreting Section 32C.
You see, this entire case rested on one specific part of the Constitution, Section 32C. This section protects the right of every person to establish, where practical, educational institutions based on a common culture, language, or religion, as long as there's no racial discrimination. Sounds straightforward, right? But the absolute biggest question for the court was, what does the word establish actually obligate the government to do? That single word, establish, sparked a massive ideological clash. I mean, does the Constitution require the government to actually fund exclusionary schools, or does it just mean citizens are allowed to privately build them? The petitioners pushed for a really generous interpretation. They argued that Section 32C put a positive obligation on the state to accommodate and fund exclusive culture-based public schools. But the state argued, no, this section just guarantees your freedom to privately build and fund your own cultural schools without the government getting in your way.
Section 3, Shield versus Sword, and Deputy President Mohammed's ruling.
Deputy President Mohammed broke down the logic of Section 32 in a really brilliant way. First, you have Section 32A, which guarantees the positive right to a basic education at the public's expense. Then, 32B guarantees the positive right to instruction in the language of your choice where reasonably practicable. But Step 3, found in Section 32C, is a completely different beast. Mohammed pointed out that while basic and language-specific education are positive rights, establishing separate cultural schools is a freedom. It's a freedom of private association, not a demand for public funding. This is the absolute crux of Mohammed's ruling. He stated that Section 32C acts as a defensive right, a shield against state interference, not a positive obligation, or sword, to demand state-funded cultural exclusivity. He reminded everyone that historically, under the Bantu education system, the state actively prohibited private educational institutions from operating independently. Section 32C was written specifically to stop that from ever happening again. It's a shield to protect your freedom to build a school with your own money. It is definitely not a sword to force the state to pay for a segregated, privileged public school for you.
Oh, and the petitioners also tried a secondary argument using Section 247. They claimed the new bill unlawfully altered the existing rights of school governing bodies without fair negotiation. But Mohammed just dismantled this.
He noted that school governing bodies never actually had the legal authority to dictate language testing in the first place. Under the old laws, admission criteria and language testing were strictly controlled by the state and school principals. So, because the governing bodies never actually held this autonomous power, the 1995 bill couldn't have stripped them of it.
Moving on to Section 4, the global lens and Judge Sachs's concurring judgment. Judge Sachs took a step back and looked at international law on minority rights, mapping it across 3 distinct eras. First, during the League of Nations era, the focus was really just on basic tolerance, letting minorities peacefully coexist. Then, post-World War II, the United Nations shifted the focus over to individual non-discrimination. And now, in the modern era, international law has moved toward affirmative action. It's all about remedial equality, actively helping disadvantaged groups achieve actual parity.
Sachs used this history to highlight a really crucial distinction. International law aims to protect marginalized groups who are trying to overcome systemic inequality. It's designed to lift up people who have been oppressed, not to lock in the historical privileges of a dominant minority. In this specific case, the Afrikaans-speaking communities were basically defending relative affluence and privilege that was built through decades of historical state support. Sachs made it clear, international law doesn't force a state to maintain separate rights for historically dominant groups just by calling it minority protection.
Sachs summed this up perfectly. He wrote, "Democracy in a pluralist society should accordingly not mean the end of cultural diversity, but rather its guarantee, accomplished on the secure basis of justice and equity." What a powerful way to frame it. He's saying that a truly democratic society doesn't erase diversity. It harmonizes diversity with equality. You simply cannot use the protection of culture as a sneaky backdoor to keep an unequal, exclusionary system running on the public's dime.
And that brings us to Section 5, the final verdict, balancing equality and diversity. So, how did it end? The Constitutional Court reached a unanimous decision. They fully upheld the Gauteng education bill. They ruled that prohibiting language testing and forced religious classes in public schools was 100% consistent with the Constitution. The government's mandate to create an equal, non-discriminatory public education system didn't violate minority rights, simply because those minorities still had the absolute freedom to go and establish their own private institutions. Okay, so what should we actually take away from this explainer? Well, it gives us some absolutely vital principles on how a democracy legally navigates between integration and cultural heritage. First, the state has an obligation to ensure equal access to public education. At the exact same time, minorities are totally free to privately fund and build their own cultural schools. But crucially, having a defensive right to protect your culture does not give you a claim on state resources to fund it. True democracy balances the mandate for equality against the right to diversity. It brings them into harmony instead of setting them at war. I'm going to leave you with this provocative thought. As our societies continue to grow more diverse, this balancing act between state-funded equality and privately funded cultural preservation is only going to become more vital. How do we respect our differences without building walls between us? This 1996 ruling is a powerful reminder that while the state has to guarantee a level playing field, preserving exclusive cultural heritage ultimately rests in the hands and the wallets of the communities themselves. Thanks so much for joining me for this explainer, and keep exploring the incredible ways the law shapes our world.